I am an estate planning attorney. I have my own practice in North Scottsdale where I do probate and estate planning. And I meet with clients of all ages, 18 and up, young and old, rich and less than rich, people who need a lot of planning and people who just want one or two things to give them some comfort and security. Estate planning and probate, I have a little slideshow. What does that mean? So some of you may know what that means because you've lost a loved one, you helped with your parents' estate, or you've done your own planning. But for others, it's just sort of, a couple of words, maybe fancy words, but they're not. So what it means is that I do wills and trusts for people. I help with financial and medical powers of attorney, I help get medical directives in order, and then I help them after the loss of a loved one. So anything from you have to file probate to just what do I do now? How do I cancel Social Security? To making sure that trusts are administered for minor children properly. So it's a big span of what I do. I happen to really enjoy it. I get to talk to people like you every day and hear your stories and your goals and your hopes for your children and things your children may not have done that you recommended against. And it's really interesting and I like it. So the last few weeks have been really busy, as you may imagine. Estate planning during a pandemic is really important for many people, and they want it done as soon as possible. And for people who have plans, they want to understand what something like the coronavirus means for them in real world terms. So I'm going to talk to you a little bit about that today. And then at the end, I'll go over any questions you have, whether they're about the presentation or just generally things that you wanted to know. You can send me questions in the chat box, and at the end, you can raise your hand, and Lynette or I will call on you. If you've been homeschooling, you are very familiar with this process. So, in times of pandemic, what most people are focused on are their medical directives. So, in Arizona, this is 3 documents. A medical power of attorney, a living will, and a HIPAA authorization. A medical power of attorney is the document in which you appoint an agent to speak on your behalf in the event of a medical emergency. So think the person that's authorizing the surgery with the doctor because you're in a coma. In the time of the coronavirus, this is really important because no one is at the hospital with you. Even if you're going to the hospital, not because of the coronavirus, you are not allowed visitors at most medical facilities today. So you need to have an agent who can speak with the doctors via telephone or video conference on your behalf. What's also really important that I'm seeing is you have to take these documents with you when you go to the hospital in the first instance. Even if you think you might not be sick, even if you go in for something unrelated to the virus, because you're not allowed visitors and you may not be allowed to go home to pick them up and no one can come and bring you a delivery, you need to take the documents with you. So for some of my high-risk clients, I tell them just make a copy of the documents you already have and keep it in your purse or leave it in your car. And that way, if there's an emergency, you have the documents you need with you. The living will. So the living will is a fairly short document, though it addresses a really big issue. So a living will says you do not want prolonged life support. There are some definitions to get there. You have a terminal illness or an incurable condition. And some people, we modify the living will to fit with their own comfort level. So some people say, I don't want prolonged life support for more than 2 weeks or 30 days. Or a lunar cycle. There's no judgment at the office. You could say whatever you want in your own documents. In the time of the coronavirus, there's a couple of really important things that I'm seeing from clients. So some people want a living will, but not if their diagnosis is from a coronavirus, because they believe that they want extra time. So you may have read the stories about one of the Broadway stars who was on the coronavirus. He hit the news, his wife has done a good job of updating people about his condition. He was amputated and he was in a medically induced coma for 31 days. So if he had a living will, it probably would not have been the case and he would have been taken off. So if it would be important to you to be on, medically supported and induced coma, you would want to have that clarification in your living will. Some of my other clients are on a completely opposite end of the spectrum. So they think that the invasive treatments needed for coronavirus care are painful, or they don't know, but they believe that it may be painful, and they specifically do not want any additional treatment or any support. So I'm modifying their living wills to make them even more restrictive so that request is being met. Wonderful things to think about. So, HIPAA authorizations. HIPAA authorizations are something that I don't see every estate planner do, and in my mind are some of the most important documents that you could have. It's very short, it's like 2 pages, most of it's statutory, but what it does is it's a privacy waiver, and it says that if you are in a medical emergency, the individuals designated can receive information about your medical treatment. They can't make decisions, but they can receive information. So classic examples that I used to have about this were the 19-year-old who went to college and had some fun and drank too much and went to the hospital, but her parents couldn't call and receive information about her condition. So I always tell my clients with young adults that they need to have forms signed before they go away to school. In the time of the coronavirus, it's been interesting because no one can go to the hospital to get the update themselves or do visits. So beyond just the young person, we really need anyone who is single to make sure that they have HIPAA authorizations in place so that loved ones and family members will be able to receive information about their medical care. So, those are sort of the overview of things that I wanted to talk about, just informational things that I see now. But what I find when I do these types of calls is that people have their own questions. So what may have been on your mind, something that you've read in the newspaper, or an experience that you had that you may want to ask about, now is your chance.
Allison, if you do not have a form or you've not designated someone to speak on your behalf at the hospital, who do they use? Is it like and you're not married, is it your parents, your sister?
So I would say it's actually a really confusing thing. So a lot of times, if the doctor or the hospital are being restrictive, they won't speak to anyone. So they will require the authorization first. So that could be really upsetting. So for the example, I get calls from adults with teenagers, we're young adults, 19 to 24. The hospital won't talk to them at all. My niece at ASU had mono. I drafted the documents for her. I told her she had to sign them. I explained them to her and why it was important. I told her she didn't even have to put her mom on it. She could put me or another family member. And when she went to the doctor refused to speak to her family.
Wow.
For other people, if you're married, usually, that can work. But even marriage sometimes isn't enough because people can be in the process of getting divorced, or they could be unhappily married, they could be estranged. And so some medical doctors and some medical hospitals are going to be more conservative than others, and it's a policy. And so there's no guarantee.
Okay.
Other questions?
Tova has a question.
Great teenagers. So I would say this is a tricky. So a lot of times when I have clients who have minor children, I don't put in their names in the authorization unless they reach the age of 18. So you can, and some institutions between 16 and 18 will honor it. Younger than 16, I'm not seeing professionals that will honor that.
Yeah, I was just curious because in being divorced, right, their ex-husband, yes, he could say he's my husband, but he'd be lying, and she would be with them, she's my daughter. So I kind of wondered if that would go. So I obviously need to have this. I usually, with my doctor's offices, I always put my brother's name down, But when you go to the hospital, I mean, I guess before I go, if I were to go under, I could put his name down, right? And that would authorize them because on intake, they ask you that question.
Right, it depends on what you go in for. If you're capable, when you go in, you can do an authorization. I think this is really planning for like the car accident where you there voluntarily and you don't have the ability to make a decision at the time. But yes, this is where people have a concern. We ask, or have people think about who could be the spokesperson for your family. So, so like your brother could be the person that receives the information, and then his job is to share it with the appropriate individuals.
Yep.
For some people who have busybody relatives, we also think about that. Don't put the person that's going to call the doctor all day, every day down on your form. Let them receive information from someone else. So I have a question. So if you are an executor of a will or a medical power of attorney, what does that mean in the COVID era for medical treatment? So if you are the agent, you need to have a copy of the documents, ideally. So for people who they believe or their parents have told them they're the agent, or they believe they're an agent for their friend or for their sibling, it's important first out of the box is where are your documents so that you know how to get access to them if you need them. So some people want to share that in advance. Other people, it's still kind of a secret. They might change their mind. They want to wait to share that information, which is totally fine. But then you need to share where they could find the information. So either call my attorney, or they're in the closet, it's on the bookshelf, it's in a red notebook. I can show you. All of my clients come in a fancy blue notebook. That can be helpful. So that's the first step is you need a copy of the document. You then are going to have to share it with the medical provider. So for my clients who are already known patients at Mayo and Banner, formal healthcare institutions, you get a patient portal. And I would say the documents may already be in the patient portal. So you could call and say, my mom is a patient at Mayo. I am her agent. You should have the documents authorizing me as the agent in her portal. Would like to speak to the medical doctor. Absent that, you are going to yourself upload the documents to the medical system in some way. If you're allowed to go to the hospital, you obviously take a copy. But in today's world, everything is being done electronically. And yes, copies are accepted. So you should always keep your own original and then make a copy. Some people save their documents on Google Cloud or in other electronic databases, and so that they can always access them electronically. Copies are accepted for medical providers.
Do they have to be notarized copies?
So, right. So you're taking they're signed and notarized. Some documents need to be witnessed, but so you would have a copy that has been fully executed. So is not in dream. Yeah. Let's see. I can tell you a story about, I have some clients who are in nursing homes, and I have had a number of visits to the exterior perimeter of nursing home and life care the last couple of weeks, because they have seen that they really want to make sure that their documents are in order and that things are updated. And even for people who already have documents, that someone else has a copy. So I'm literally sometimes just picking up copies and scanning them in and creating the electronic file and sharing the electronic file with their family members. Candice, you have a question about a trust?
Sorry, I came in late, and is our trust questions part of your agenda for today? Because I noticed it. Okay, so we processed a trust with a private attorney, and that was a long time ago. And since then, we get the sense that it wasn't a completed process, and we've always wondered who to ask. And here you are. So thank you. I still get my mortgage addressed to me as an individual, which was a hint that maybe there's no trust name associated with the house, so that it was an incomplete process. And you should know that there are not a lot of other assets, so I don't know what the heck got accomplished for the first process, since we don't have a second house, we don't have multiple, you know, private properties. We really just have the house. And so I have this big binder that I got, and at the very front, there's some empty paperwork. Am I supposed to be filing things on my own that this agent wasn't capable of, in their defense? And of course, there's no point in being angry now. What's the next step so that this is a complete process? Because all we have right now that shows a trust is our bank account.
So I also only have one house, so there's nothing to feel bad about.
Well, I just don't know why, if you pay someone to process everything as a trust, what is in this huge binder if our house wasn't processed? So I'm confused. But that aside.
So this is a great question. Actually, I had a realtor call me yesterday to tell me that a client thought the house that her mom had was in the trust. Her mom, right, spent a lot of money on a trust, and now she has to go through probate anyways. So it's good if you're identifying this issue outright. So how you know if your house is in the trust? One, your tax statement should come in the name of the trust. So the Gimbel Family Trust is on the tax statement that you receive every year. Two, you go to the Maricopa County Assessor's website and you put in your address, and it will show the owner of the house, either your individual names or your trust names.
Which website was that?
It's the Maricopa County Assessor's website.
Okay, thank you.
And for anybody not in Maricopa County, every county has their own assessor's website.
Yeah, I did that, and I did that once, and it didn't come up with our name. I mean, it came up with our personal name, so that's a problem.
Okay, so let's say I'm happy to take a look at your notebook. You might just need a deed, so that's like a simple thing, but you then need to deed your house from your individual names into the name of your trust. It's simple, 2 pages, but those 2 pages are really important for the future. Yes. And if you signed one and there's one in your notebook, then you need to take it to the Maricopa County Recorder's Office to have it filed. So the good and bad of estate planning is that there's a lot of steps and you have to make sure that they're done. And when I work with clients, one of the biggest things that I find are, yes, the house is not in the name of the trust, but also people think they have an estate plan, but it hasn't been properly executed. So it's not signed, it's not notarized, it's notarized, but there's notary stamp, or it's not properly witnessed. So these are sort of little things that you want to double check or have a professional check for you.
Is that a symptom of a do-it-yourself kind of culture that you see? Oh, you don't need to hire someone, do this online, or do it yourself with a software package that leaves things unfinished?
So definitely the biggest problem with the online documents is that you get documents, but then you don't know what to do with them after that. So they have to be properly notarized, witnessed, and signed. And there's a lot of different links for that, and you have to fill that out correctly. So the other problem I see with some of that is you're typing in your own information, but I see a lot of misspellings. So, you know, things are going to your daughter, you forgot your son, or you wrote your daughter's name in wrong, in which case we have to fix that. A lot of the online processes, they only send you PDFs that are not editable. So you either have to repay or you have to hire someone who can give you a Word version so that that's easier to fix. So I have a question about getting started. Definitely getting started is the first hurdle, right? You have to take a deep breath, like I'm gonna do this. I think about it like insurance. You're gonna do it once, hopefully you do it right, and you're gonna forget about it. But if you need it, it's there for you. So most of the initial process is really just you and or your spouse deciding what you want. Who would be your agents if something happened to the both of you? People always say, well, my spouse will do it. We're really planning for either you and your spouse to pass together, for you to not have a spouse, or for you to be the surviving spouse. So aside from your spouse, who would be there to take care of your things? Who will be there to take care of your children? I do this even not part of a full package, but if you and your spouse are taking a 2-week couples trip to Italy, you should do a temporary guardianship before you go in case something happens to you or something happens to your children while you're gone. Other things are just, who do you want to inherit? And how do you want for them to inherit? So you think, okay, I have 2 kids, it's going to go 50-50. That's the easy answer. The harder answer is, at what age? You know, are they inheriting $200,000? That's not responsible for an 18-year-old in some cases. Sometimes not even a 25-year-old. I think I would have traveled the rest of my 20s if I had that money, and that may be okay with you. And so part of that is figuring out what is the money for and when would they be responsible with using it. So you want to start making some hard decisions and thinking about it. And then, you know, I have a worksheet. Some of my family members have worksheets outstanding, which is okay. But that is kind of the process.
If you're divorced, you have your own directive and how you want everything to go. The other person does not need to agree with, it's all separate.
Correct.
So what if I have a trust and my trust is I want to have it left to my children? Does he have to have any, in their minors, does he have to be on it, or will he manage their money?
So there's a couple of things.
Sorry.
So trust funding is a big issue. So the answer is, for my clients who tell me, I want this money to go to my kids, but not my ex-husband. He can support them. He's obligated to support them. I don't want him to touch my money. Then we write that in. That says that the kids will get the funds, but at a certain age. If the kids aren't minors, sometimes I still write that in, which is my children can inherit, but not if they're going to give the money to their parent. For other people, you know, we like to try to agree on guardianship for minor children if at all possible. But if we can't, I always assume that the ex-spouse has passed. So I don't write their names in the documents, even if they're legally obligated to be the guardian, because you want to have a backup. I see this used in order to allow grandparent and or other family members to get visitation rights if something happened to you and the spouse has custody.
Could you write that in about the visitation? Like he gets the custody, but only assuming they get, you know, a reasonable, I mean, obviously I would talk to him about we probably should have that conversation. What happens to me? What is reasonable for visitation for my parents?
Right.
I mean, we've been good about it in our divorce, but
That's
if I'm gone and he moves back to California, then what kind of visitation do my parents get?
A paragraph that I have tried to perfect as best as possible with other family lawyers, so divorce lawyers in particular, to make sure that particular grandparent visitation rights are honored. And sometimes we even have the other spouse sign something that says that they will honor it. So I've read the will. I will agree to allow for visitation for grandparents on these terms. So it's sort of like a post-decree, you know, agreement. Other questions people may have?
Do you do this with your attorney when you're going through the divorce, or do you do this after you have all your divorce papers final and then you sit down with you and start putting my own wishes together?
It could be either. If it is an amicable divorce and you want to work these things out as a couple, then I try to do it as part of the process. And really, I just work with the divorce attorney to include some additional provisions in the agreement. If it's not going amicably, then you just sort of, again, we assume that you're the surviving parent and move on from there separately.
Okay.
Some of my clients, I had a call earlier this week from a woman who's actually going through a divorce. She finished mediation and she's getting a very large settlement. And she needs her trust to be set up ASAP so those funds can be deposited directly into a trust account so that they get protection from creditors. And
does anybody else have any questions?
I have one more. So Allison, you were talking about, because I hadn't thought about this. It's one thing to say there's an executor and my daughter gets X, Y, and Z, and she's 12. Directives on how to liquidate the assets, right? Because it's just me and her. So when God forbid it's when she's young, everyone, knock on wood. But presumably, like, she's not the one who's going to clean out my house. If she owns my house, it's not her. How do you accommodate that?
so we do it a couple of ways. So the first is you're choosing your brother or parents to be the agent. So they are carrying out the administrative duties, but they're doing it on her behalf. So as fiduciaries for her. So things like stuff is hilarious. I mean,
It's the worst.
Gotcha is what people fight over. So, you know, for my minors, where the minors are beneficiaries, the trust will say she can choose what she wants and you'll keep it and either pay for the storage or someone will store it for her. Sometimes we say, you know, keep it until she's 18. So keep all of the stuff, all of the jewelry will be kept until she's 18 and then she could decide what she wants or what's going to be sold. But the important part of choosing an agent is that you choose someone who can handle your wishes the way you want them, to work well with the beneficiary, so to honor their wishes, and someone that's not going to be self-interested. So either I don't have time for this or I'm going to take this for myself.
That makes sense.
So you're doing the best you can while the kids are minors and until you feel comfortable that they could take over the job themselves.
Do you have people that, like, I know when someone's elder, there's fiduciaries that do take this on. Are there people, like, because, you know, I'm 54, my dad's 82, like, he's not going to do it. My brother, who's got a family of his own and a full-time lawyer who's busy all the time, he's not going to do it. Are there agents that you could hire to be that person and take care of it and are fiduciary bonded?
Yes, so there are certified fiduciaries, a lot of them in Maricopa County, but there's also, your bank probably has one. There are many fiduciaries, so you could meet them in advance so you feel comfortable with them. Some of them are big institutions and some of them are just, you know, smaller, you know, one or two individuals who handle administration. And you can do everything from appointing them as co-agents. So if you wanted, you know, your brother to make the decisions, but he can't actually clean out the closet, you would pick them together. Right.
Allison,
I mean, this is like the biggest aha moment for me on this whole call. It's like, oh my God, like, because I don't even want to go through that.
Allison, did you see the question about are wills and estate plans from other states valid?
Oh, I did not see that question, so I am sorry. Are they valid? So the answer is some things. So the law says that the documents are valid under the law of the state in which you have passed. So if you've moved from California, your California will or trust will be valid and enforced according to Arizona law. California to Arizona is pretty easy. We're both community property states. If you come from not a community property state and you have separate property, then you should execute Arizona documents to reflect that you are either disavowing community property or are accepting it. The harder thing is powers of attorney. So your financial and medical powers of attorney from other states are not likely to be enforced. I could say banks are definitely not taking them. Banks are I spoke with a banker earlier this morning. Banks, the biggest problem, they're always worried they're going to be sued or they're going to give money away improperly. So they're really restrictive. And most financial institutions now are not accepting documents that are less than 2 years old. So that is a document you'd want to update. Healthcare powers of attorney, HIPAA authorizations, those should also be state specific. For some of my snowboarder clients, we just do a whole bunch of them. So they RV to multiple states and we do one for each state. So if there's ever a question, they have the specific one. And really the import of that is not so much that the document that, medical provider doesn't think it's legal. The difference is a medical provider doesn't know what the document is. So things like formatting and language and statutes, that's how they know it's valid. And they don't want to have to be guessing if you're lying and presenting them something from Georgia and they don't know what Georgia law looks like.
Makes sense. Does anyone else have any questions? I think we're good then.
All right. Thank you so much. I really appreciate it. If you have questions, feel free to ask offline, call me or email me. It's what I do most of the day.
Yes, thank you very much. You were so
Great,
informative and helpful. Thank you.
Yeah.
Thank you.
Bye, everyone. Have a good day.